Okay. This is our discussion meeting. We're not going to make decisions today, but we are going to have a work group meeting that I hope everybody can attend on January 5th. And I'm thinking that we'll probably make some decisions then. Here's the status of, but we're having these meetings because frankly, we had an irreconcilable conflict between Dave's schedule and Maya's schedule. And I think it's important for us to hear from both of them. So we're not going to make any decisions in the absence of either of them. But we have a lot of catching up to do. So we'll just talk about that. I'm going to just give you a little bit of a summary of where we are, and then talk a little bit about the Pretrial Justice Institute study that's generated so much controversy and so much email. Where we are is this. We, as you know, we identified the risk assessment tool we were going to use. We got the funding for pretrial services. We set up the pretrial services department. The pretrial services staff and Dave went through several days of training on the software that uses the Arnold Foundation Public Safety Assessment. And literally, we were going to launch pretrial services with the public safety assessment the following week. And then we had to shut the court down because of COVID. Talk about awful timing. So we have not used the public safety assessment, although we're totally ready, trained and got all the supplies and everything we need. Instead, our courts have been, frankly, working really hard not to incarcerate people, which has made a huge change. I think Dave Graham can testify to this, huge change in our pretrial policy. And this is all pursuant to the orders of the Supreme Court, which say basically to the superior courts, try to figure out an alternative to incarcerating somebody. So we've got the prosecutors appearing before us and asking or agreeing to personal recognizance of nonviolent criminals, and we lump the felony theft offenses into that group, which I think is appropriate. And then for the people who are charged with violent crimes, again, the pretrial conditions and the bail amounts have gone way, way down. And so as a result, we have managed to keep the jail from overcrowding. An interesting side effect is that the group of people collectively who are in the jail are charged with much more serious crimes as a group than was previously the case. Although, you can see that as a bad thing or a good thing. Because we've got a bottleneck in that we don't have trials resolving people's cases and getting them out of the jail, we've got more and more people piling up with who are in pretrial status. And obviously we've prioritized that only the people who really need to be in jail are in jail. So I think that's going to leave lasting effects in the court system. I'm just speaking as myself now. But I really think that we'll have a lot of data to look at simply about the pretrial experience of people that have been released on recognizance for a long time. And we'll be able to see what kinds of risks there are there. On a demographic level. As for our pretrial services office has continued to function, and our internal policy approved by the judges way back when has been that when people violate their pretrial conditions, which used to include coming to the pretrial office in person for some defendants, but now no one comes to the pretrial office in person. They do remote contacts. But we have a policy that if a person violates pretrial conditions in some way other than getting new criminal charges, then that's handled administratively within the pretrial services office. It doesn't come to the judges. If the pretrial services officer has a question about it, well, I'd say he or she, but he will go to one of the commissioners to see if further action should be taken. But that's important because it minimizes the risk that people will get incarcerated for pretrial services violations, as opposed to for, stuff that's directly related to their charges. The one exception is when a person is charged with a new crime. And when they're charged with a new crime, the pretrial services department brings that to the court's attention by noting a hearing. And the court does one of many things. Sometimes we talk to the defendant sternly. Sometimes we lock the defendant up, or increase bail is what I really mean, or impose bail if there's really a threat. And a lot of times it's somewhere in between. We might make a slight increase to the person's bail. We might make a modification to their pretrial release conditions. We try really hard not to incarcerate people because we don't want a COVID outbreak in the jail. But there are some people who really have to be incarcerated because they've acted so badly. Mostly not. Most of the pretrial new crimes, people that come before the court end up with some sort of increased restrictions, but short of incarceration. And would you agree with those generalities, Dave, Graham? Yeah.
Yeah, that's correct. You nailed it right there.
Yeah. So as a result, we've been able to keep the jail below its maximum capacity, which is good because it's bad in the jail anyway. And when it's at maximum capacity, it's downright inhumane. So we've been able to avoid that. And I think we'll continue to avoid that. Certainly the orders we're getting from the Supreme Court continue to prioritize finding alternatives to putting people in jail. The other thing we do when people don't come for a hearing, under a previous prosecutorial administration, the court was urged to issue a bench warrant the first time somebody didn't show up, and then they could later be charged with bail jumping, also a felony, really serious consequences. But under Eric Ritchie as a prosecutor, that policy has changed. So they don't charge people with bail jumping unless they've actually jumped bail, like fled the jurisdiction. Instead, even if a bench warrant is issued, it can be quashed and is quashed pretty quickly. We've stopped issuing bench warrants that involve bail or other conditions for the most part. Now, when we've tried to reach a defendant and the defendant just isn't coming to court, what we'll normally do is a book and release bench warrant, which means that the police arrest the person, bring them to the jail. The jail fills out some paperwork, gives them a hearing date, which is like the next day or two, and then releases them. So they don't actually get incarcerated, but they do get formal notice of a hearing that by God, they'd better be at. And they get it from the jail. So that's a way of getting the attention of defendants who are thinking that maybe this is all just going to blow away with COVID. So that's what we've been doing during these times. And really our purpose, the reason that we need to get together now is, one, to make some decisions about how we want to proceed with our risk assessment tool and our pretrial services, or at least what we want to recommend to the judges. This will be a judge's decision, obviously. Two, to kind of wrap up my involvement, at least in my official capacity, because my last day of work is January 8th. I can't believe it, but it's true. And also to address the, the 900-pound gorilla in the corner, which is the pretrial justice criticisms of risk assessment tools, which I think our group has a variety of opinions on, and some of us may have no opinions at all, or at least be open to hearing about it. So those are the three things that I see us needing to do within the next couple of weeks. I think I told you this by email, but just to be sure, Judge Dave Freeman will be the judicial representative to our group. He'll be the representative both to our work group here and to the Legal and Justice Committee of the task force. So he'll basically be in the position that I've been in these last couple of years. And I think those of you who haven't met him yet, I think you'll really like Judge Freeman. He's a very good judge. And he also has a background as a prosecutor. He was a prosecutor for a while here in the Whatcom County system. And then he left the prosecutor's office and became a hearing judge for the Office of Administrative Hearings, doing state hearings, and also being the go-to pro tem judge for a lot of the courts, including ours. So he was able to hit the ground running when he joined us in pre-COVID times, but only just. It was in January, I think, when he started. So I've talked with him about the task force's work and our group's work, and he's pretty enthused about it. And I think he'll be a good addition to our group. I've asked him to join us on the 5th so that I can formally introduce him and we can talk about some of these things and have a bit of a transition. I'm not going to stay with the task force in the same capacity that I've been in. My heart's really been in this work group, and I'd like to continue with this work group, but as just another volunteer, not the representative of the judges, but just a concerned community member, nice retired lady who's volunteering some time for this group. But it'll be Judge Freeman who's the link to the judges. And of course, we all know the purpose of this group is to advise the judges, not to make the decisions ourselves. So that's where we are. And I don't know where you want to go from here. I think what I'd like to do is hear from Dave Reynolds, and it looks like John Krause is with us also. And I just would like to hear from both of you about the status of pretrial services. I just did the criminal calendar this morning and dealt with 3 or 4 cases where we had notices from pretrial services of new criminal charges. But I don't know about what's going on administratively, and maybe you can bring us up to date.
I'll go ahead and ask John to report on the numbers that he has.
Hi, John. John, you need to unmute. Are you with us, John? I've got John's name on my screen, but I don't see him.
On mine too. It looks like his microphone's off. I'm not sure he has a microphone on his computer, so he may need to phone in.
Is the phone number in the email that Jill sent us?
He may have stepped away from his desk. I don't know if you guys have physical access to him. 2
floors up.
Okay. I'll send him an email and see if he...
What I can report from John is
Thank
that
you,
there's
John.
currently 197 individuals on pretrial. Of those, 99 are medium level, 65 are low level, and 33 are high level. There's really no difference in between reporting requirements between low and moderate. Overall, in the last month, there's been an 81% compliance rate. And in the last 6 months, 90%, and compliance is being deemed as checking in with pretrial services, not necessarily new offenses.
Those sound like excellent numbers.
And I don't know if Dave Graham might have information on new offenses.
Well, I guess I'm just, one thing hopefully when we get John here, I'm curious about it being in compliance. If that means they've had contact with these people on low and medium, or does that just mean they're just advising them of court dates?
No, according to what he sent me, is defined as checking in.
Checking in, okay.
Yeah, it's not. He hasn't explained anything further than that.
Okay.
So I don't know if it means court dates or new offenses. I'm assuming not. So I
Dave,
don't know
you
if you have
said-
any additional information on that, Dave.
Well, I know our new offenses, we've been seeing a lot of, is that John there? Oh no, that's someone else. We've been seeing a lot more, and my biggest concern is that we have so many people right now who are kind of out of touch with the court system, that no one's heard from, either the prosecutor or the defense attorney. And a lot of times we're kind of looking at pretrial services to maybe give us an update if they've heard from these individuals within a month, 2 months, 3 months, or 4 months. And we don't have that inside the file, so we can never know. So that was going to kind of be one of my suggestions, is if we have some sort of, if they're able to, and I'll ask John if it's too labor intensive or not, to sort of create a report for people for status, so the judge can be able to see, oh yeah, pretrial service talked to this person in August or talked to this person in July. Because yeah, we have a lot of folks, I mean, who haven't been in the court since February, probably haven't talked to their attorney since this summer. They're just kind of, we're just kind of continuing along, and then eventually we're issuing these bench warrants, these book and release bench warrants. But that was going to be my question to him about that.
Should we be expanding the definition of compliance to include court hearings and new offenses?
Well, I would definitely say new offenses. I don't know about court hearings, because as long as they maintain contact with their attorney, then I would think they're in compliance. But I'm curious what the numbers are, how many people may be compliant with pretrial services but aren't showing up to court.
Not with anything else. Yeah.
Yeah, not doing anything else, because
Yeah.
that surprises me that there were that many compliance, because I know there's a lot of cases we call that no one knows what's going on. We look, they're on pretrial services, but no one's heard from them in months.
Yeah, I think that would be helpful to have that information as well, definitely.
Yeah. So
I agree.
that's maybe something we can talk to John about, as kind of an idea. And I know I talked to Judge-elect Jones about it, and he said, oh, it'd be great at status if I could just see something like, oh, they've been in touch with pretrial services. That would kind of delay issuing a bench warrant, because I know they've at least checked in with somebody.
Yeah, but it's true. There are a lot of people out there in the community that we've just lost touch with. And a lot of defendants live a pretty scattered life. A lot of them are homeless. A lot of them, we just don't reach them. And that's when we finally start picking up and actually processing our cases substantively instead of just continuing them, that's going to be a big problem.
John is with you now by phone.
Okay, good. Hi, John.
Hi there. I was having problems. I don't know what it was, but I'm unmuted, of course. So anyway, overall, Dave just read the numbers. Mr. Reynolds read the numbers about how many are on our caseload. And we're keeping track of all the new charges while on pretrial. And we turned in one Excel back mid-August, and then we've been keeping track since mid-August again. So we got 2 little sheets. But overall, we had 94 defendants have new law violations while on pretrial. And that includes either misdemeanor or new felony.
And is that 94 of the 197 on pretrial total?
Correct.
Ooh.
And that, we didn't break it down by levels. That could be done. It'd take a little work outside this meeting,
But still, if we've
and
got
some of those
94 with new charges, go ahead. I'm sorry.
I just 94 could have been August measuring and after we kept 2 lists. So some could be the same offender, maybe up to 10, 8 to 10 of them repeated with several more violations, but seems to be pretty high.
And at this point, we're not using the PSA at all, are we?
Not correct.
Can you remind us how the decision is made regarding which defendants are on pretrial monitoring at this point?
Well,
I hate to be flip, but I do a lot of the 3 o'clocks. It is purely random. Sometimes the defense asks for it so they can get a PR, lower bail. Sometimes the judge does it, but it is purely random. Like I've gone a couple months where I haven't had anyone on. But then every once in a while you get a day where there'll be like 3 on. But it is pretty hit or miss. There isn't really a scientific method right now.
One piece of my concern is, again, I have a specific focus on the domestic violence and sexual assault cases, and I know that's often off to the side of the main focus of our work. But I am still interested in looking at the possibility of having those cases specifically referred for pretrial monitoring. You know, one of the things that I see in small cities courts recently is fairly frequently it would be no contact order violations of a pretrial no contact order on a domestic violence felony assault case, where bail was initially set, somebody posts bail, they're released, and they're continuing to violate. And we often really don't see much follow-up on those kinds of violations. And I suspect that those are cases where the pretrial services unit is not monitoring them because they're cases where that we kind of separated from that whole consideration for the PSA and for pretrial services. And that's still feeling like a bit of a gap to me. I don't know where that discussion fits, but I'm interested in picking that up at some point.
Yeah, I think that's a great idea. I don't think the judges or the commissioners have been putting people on pretrial for DV cases. I think they've just been, doing these sort of property crimes, other sort of crimes, and just like imposing some bail on a no contact order and figuring that's enough. But I agree with you. We see so many repeat violations of no contact orders that it would be great if they could also add that piece.
Yeah.
And make them higher, because again, we're not concerned about them checking in, getting reminders once a month. We're more concerned about them not being in violation. Something like that, we'd like them all to be on, like, especially DV cases, on high supervision. I think that's a great idea.
And that's something that can be done fairly easily, with better communication with the commissioners. Yeah.
I guess my question would be, what's the expectation of monitoring that would happen in those sort of cases, given our limitations? I mean, we have 2 staff on 197 people. We can't see many of those in person. So what's the expectation if we're providing additional service for DV cases? Not that we shouldn't, it's just that what's the expectation with that?
Yeah, I guess it would just be to put them on high supervision when we eventually have this where they can report in and just keep better track of them. And maybe it means letting go of some of the small other case. I don't want to say smaller cases, but some of the others. So, if you do have, 25 high supervision people, maybe you don't need 100 low supervision. You can kind of, knock that down some way, realizing that someone on high supervision is going to take more supervision than.
Well, I think John could probably speak to this, but there's not a huge difference between what we're doing with high risk versus medium and low, just based on the limitations.
But that's partly because of COVID, because
yeah, exactly.
Yeah, in-person contact is required a lot more for high risk people, but that all got sort of merged into telephone contact because in-person contact isn't appropriate right now. Yeah.
I think one purpose for adding supervision for the domestic violence cases would be to have a more immediate and predictable response to violations. And I appreciate the consideration of a range of responses, not just sending people back to jail, but I think that consistent and predictable, no, this is the line, don't cross the line, there's going to be a follow-up to this, is a useful message in many of those cases.
Yes. Plus, I think pretrial services are good for just keeping the case on the defendant's mind, because as it is, defendants go away for a while, and in an effort to reduce the number of bodies in the courtroom and in the courtroom especially, and the courthouse generally, the Supreme Court has authorized lots of alternatives that involve the defendant getting together with their lawyer, probably remotely, and agreeing to an order that's then submitted, maybe on paper, maybe remotely, but the defendant doesn't have to come into court. So most of our defendants, I would say, the people who were charged before March, they might have been in the courthouse once since then. And even though their cases are getting continued every month or two, it's all on written stuff that they sign with their lawyer. It used to be at their lawyer's office. Now that's become remote too. So, so I think it's easy for defendants to just blow off a case. And those are the defendants that are staying in touch with their lawyers. Then there's all these other defendants that we haven't heard from. And we go through a number of steps before we issue the bench warrant. That includes the prosecutor's office having to send out a summons at least twice, sometimes three times, checking, doing skip tracing to see if there are more current addresses, doing what they can to actually reach the defendant to let them know that there are charges. And then we hope that we'll see the defendant in court. But there are a lot of people out there who are just not in touch with the court, and the court's not really in touch with them. So the one other thing that I wanted to say, and Andrew, then I'll turn the floor over to you. This is on the subject of risk assessment tools. Not that that's an obsession, but I just wanted to point out that one of the things a good risk assessment tool will do is it'll define the level at which people should be referred to pretrial services. And if it's done right, there's going to be a whole group of people whose scores are less than the level. So unless there's a reason in that particular case to assign them to pretrial services, presumably the court would not do that. So, if you've got a total of 10 points, it's a policy decision where the court wants to have presumptive low-level services, but it's not like, everybody with a score of 1 up goes in for some kind of service. So the court can decide whether 3 is going to be the point at which low-level services are offered, or 4, and at what point do we go from low to medium and medium to high. Those are all court decisions, but if you're doing it right, there's a group of people who score low enough that the court just, sends them away and tells them to come back for their next court date, and they don't have any monitoring. Obviously, we'd like to increase that group.
Just very quickly, we did actually administer the PSA for a couple weeks before COVID hit. And if John can correct me on this, but I don't believe it was producing a risk level for supervision. It was simply saying hold or release. Is that correct, John?
Yeah, there was a matrix on there that scored them.
Yeah.
Low, medium, high. And then but is that kind of answering your question?
But what was it showing to the judges? That's what I can't remember, because there was a question at first about the information that was showing up on the PSA that was going to the judicial officer for review. I can't remember, was it something to do with bail, or was it to do with the risk level?
Do with the risk level.
So they were getting the risk level?
Correct.
Or they weren't getting bail, is that right?
Yeah, it didn't recommend any bail.
Okay, that's what
Oh.
it was.
On there.
Okay.
No, in fact, the risk assessment doesn't recommend any particular pretrial conditions. And as I recall, the risk assessment, if you put all the data into the risk assessment will give you a number, and that number might be 2, might be 9, and the judge is aware of the number. And then as an internal policy, the court decides, where the presumptive cutoff is going to be. We might decide that anybody with a score of 3 or less isn't going to get pretrial services unless, the judge decides differently. Presumption is always something that gets tailored to the individual facts. But it was my understanding that we were getting a number. Certainly we can get a number, because that's the number that, the pretrial services assessment, the public safety assessment, produces a number. And then, we have, remember this matrix, right? That this tells you, if a person is at X number, I'm not holding this very well, X number here, and this is the seriousness of the crime, then these are the levels of pretrial services that we would have. And that's something that the court can change. If we find that we're putting 90% of our defendants into pretrial services, then we probably want to up the up the standards. Maybe that would be lower the standards. I don't know, but you know, make pretrial services not happen for more of the group toward the bottom of the risk matrix. Yeah. Anyway, I think we can get a number from the PSA pretty easily.
I just remember there was some missing piece of information the judicial office was surprised about, but it might have been the bail.
Okay.
So,
And Andrew, you wanted to say something?
I just wanted to clarify something. I had a question for John to clarify. When he said, so 94 new offenses out of the 100, is that out of the 197? Or if an individual has multiple new offenses within that time, can that be counted? Are they counted more than once in that 94, I guess? Is that 94 out of 197 or is it 94 out of a bigger number? That makes sense.
94. Can you?
I'm sorry, John, I couldn't understand that. Can you say it again?
That's 94 out of the 197.
Okay, thank you. I just wanted to clarify that. Thanks.
Yes, Carol.
This is a question I think the group is far beyond, but it's not possible to complete the PSA with information available remotely. I guess I'm still a little bit confused about why it's not possible to use it under COVID.
It is possible to use it with information that's available remotely because we chose a risk assessment tool that doesn't require an interview with the defendant. So that, yeah, that information is available to pretrial services. I think, frankly, that when the COVID epidemic really affected public health planning of all kinds, it knocked our court into chaos too. And now we have, you know, hundreds of cases where we just come back and continue the case for another 2 months usually. And it didn't seem practical to put those cases into pretrial services because there were just too many of them. Perhaps we dropped a ball there, at least with some of those cases, although, you know, pretrial services were ordered obviously in 197 cases, but that's part of why we're here, so that we can get back in action. Yeah.
part of the decision not to do the PSA during COVID is we couldn't perform the level of supervision that the PSA would reflect. So it made little sense to do that.
And we weren't going to get statistical information that would be valuable to Andrew because the times were so extraordinary, are so extraordinary. Yeah. Hi, Bruce. Nice to see you. You got anything to add? You're muted. There you go.
You know, I don't. We're in terms of our pretrial, we're just plugging away here. It's we're doing some. We're able to do some Zoom appointments, a lot of telephonic with our pretrial folks. We're still able to do substance testing, but we've had to really rethink how we deliver the services, and we're not done rethinking how we can do that. It's everything's working, but it's been a lot of challenges in
I understand.
getting it to work well.
I understand. And it's always a work in process.
Yeah.
You're always fine tuning. Yeah, our court did one jury trial. It was a 6-person jury trial in the beginning of November. We did it all in-house and at the Civic Center building. It was the kind of trial that I thought would be no big deal. It was a really big deal. But we did that, and then we were prepared for 12-person jury trials, and we really were, you know, going to give it our best shot. And I think we made so many plans, but ultimately the COVID rates just surged, and we ended up deciding, as I think most courts in the state did, that it's not right to bring jurors into the courthouse for court proceedings when public health is in this state. So, you know, but look, we've got the vaccine, and that's, you know, help is on the way. Things are going to change.
I was just going to say about that trial, as far as, I was really glad that was able to actually happen, because we've done so much planning for the jury check-in and that orientation process and getting the jurors together, getting them lined up properly. It went very well, but that gave us a chance to actually test out with the 6-person, the smaller group, to test out that part of the process. We had a lot of support from the judicial assistants and Superior Court staff, and in the handoff after the check-in and the orientation to those staff members, from our perspective, went very, very smoothly. And it was very different, as you all know, because every part of it was different. But getting them properly checked in and getting the orientation completed really it was great practice for us. And I think that I'm really happy we at least got one slipped in there, because it's that experience really is allowing us to do some fine tuning for future at some point. So,
and we did learn a lot from that experience. We ended up keeping the jury in the Civic Center building and bringing them over to the courthouse in 3 different groups to do jury selection. It is amazing.
yeah.
All the things that have to be done, wiping surfaces, and jurors don't know where they're going. So, when you send them over to the Civic Center building, you can't just send them over. You have to have a person escort them. And then you have to have people in the building there to receive them and get their papers from them and put them in the right seat. And I would say we had, at least 20 staff members working on that trial. Wouldn't you, Dave and Bruce? It went smoothly, but I was thinking, how are we ever going to do this as a routine thing because of the staffing needs that it involved? But it's true.
Yeah.
We learned a lot from the experience, and fortunately, we mostly learned by not messing it up too badly. I think we ended up with a fair trial for everybody.
Yeah.
Yeah.
Bruce and I and his staff had a lot of planning on that. I mean, months worth.
Yes.
It was good. When they got to the stage, we could pull it. These are the things we couldn't plan anymore. We did everything we could.
Yes.
I did want to give a special thanks to Bruce and his staff too for sending out all the text reminders for Superior Court pre-trial defendants. I think it's been very helpful.
Yeah, they're still going out. We're
Appreciate
still do them every day we get the calendar. So, yeah.
So on to the next topic. Just informally, you've all read the pretrial justice article and perhaps some of the others that have been flying around. I expect that we'll have a discussion about whether any pretrial risk assessment is useful, and whether the downsides of risk assessments outweigh the advantages. I don't mean outweigh. Yeah, outweigh. And then, of course, there's the discussion about whether pretrial risk assessments are their disparate impact on minority people, and whether that can be alleviated, how that can be alleviated. I think that the Pretrial Justice Institute, while its logic is, I think, questionable in some areas, at least in terms of a pretrial risk assessment for us in the trenches who actually do these things. Nonetheless, they make some good points, especially on policy. And I think that it has sparked discussion everywhere. Our group met with representatives of minority advocacy groups. It'll be 2 years now. And Stephen and I and Carol, who mostly did that discussion then, are going to be talking about making a plan to meet with advocacy groups again, to update our discussion, and perhaps to invite new players on the scene. I think a lot has happened in the last 2 years, and that's included some new advocacy groups, including an official county task force that our executive has appointed. So that discussion will go on and be part of what our group does. But what are you all thinking about what you're reading about pretrial risk assessments now? Are you questioning what we've done and whether we should be backing up? I'll put you on the spot, Dave Graham. What do you think?
That's what I was going to jump in. And, of everything I've heard and read, that the best sort of summary I got was from Dr. Peterson, talking that statistically risk assessments show that it keeps people out of jail. I mean, that's what they show for everybody. You know, they're not racial discrimination in that people get out of jail. And so that's been kind of our goal all along. I mean, I'm sensitive
Yeah,
to
that's why we established the task force.
yeah. I mean, I'm sensitive to everything, but I'm more of a numbers person in that seems to be what these risk assessments do. I think we do need risk assessments. I think Carol brought up a great point too about on these DV cases, we especially do. I mean, if we're looking to sort of monitor these people. My other big concern right now is we have a lot of repeat offenders, as John Krause mentioned. You know, we're about 50% of the people are committing a new crime while they're on a pretrial. And that's just our pretrial people. That's not our other people. You know, we've had sort of a run of individuals who have picked up 4 or 5 felonies during this period because we can't process them. We can't do jury trials. We can't do anything. We don't want to hold them in jail because they have property crimes. And as a result, they're picking up, you know, more and more charges. And it'd be nice to sort of pick these folks, which ones really need some pretrial supervision, and would this help them? Would it keep them from committing another crime or not? So I'm still in the full speed ahead. I mean, I'm sensitive to the concerns that have been raised, and it's something we can do. And I think by tracking our numbers, we can see, are we being racial disproportionate? You know, are we holding more people of color or not? But I think we have to do the process to see if we have, and then make some adjustments if it turns out we are doing it. But I mean, if the risk assessments mean more people are out of jail, we should probably stick with it.
Yeah, that's why we did risk assessments. What do you think, Carol?
Oh gosh, I think I would also say that Dr. Peterson described this best at our last meeting, and I don't know that I can say the same thing as well, but it seems there's quite a bit of tension between efforts to do the best we can with the system we have and efforts to really radically rethink and rework the systems that we have. And a lot of the concerns about risk assessment instruments have to do with people desperately wanting a radical reworking of the systems that we have. And I know that, you know, those efforts are going to continue. And meanwhile, we are in the system that we have, and it seems that the numbers, the data support that using a pretrial risk assessment can help us do a better job with the system that we have. So that
makes good sense to me anyway. I don't know. Dave, Bruce, you want to jump in?
I'm definitely very data-driven in my decision-making on things and support of things. And I agree with what Dr. Peterson said. I do think it's important, however, to make sure that we've got proper resources in place to respond to whatever the risk assessment comes out and says. And I think having that information and not being able to respond doesn't make a lot of sense. We really have to have those resources there.
Yep, fair enough.
You know, I agree with everything that's been said, and Carol, what you said really caught my ear, because I think that's very true about the different dynamics that are going on over this topic. But I'm not going to use judges as an example, but I'll use probation officers as an example, because we do risk assessments for people who are put on probation. And my example is this: are we better off using a standardized tool, using the best tool that we can, that gives us the best data, or are we better off relying on a staff of 11 people who bring their own personal bias and their own personal perspective into the job with their own filters? I mean, what will be more consistent? An objective risk assessment, knowing that it's not perfect and that it may have some flaws, given that we don't control who does or doesn't get arrested, or who does or doesn't get prosecuted, and we don't control any of that. But are we better off using a standardized risk assessment that's been found to be valid, or would I be better off having a staff of 11 probation officers randomly making a decision which we know they're busy, they're going to be done on the fly, they're going to bring their own bias. So that's why we use it in probation. I don't want to use judges as that example, but let's face it, plenty of other people have done the same thing. So, but that's how I look at it is it, which is either one perfect? I don't think so, but is one better than the other? I think so. Yeah.
Okay, and Andrew, I deliberately left the last word to you.
Oh boy, that's a lot of pressure. All right. Well, I mean, I think you've all made very good points. There's 50, 60 years of research saying that, these tools, when you can formalize the decision-making process and use the evidence to then go check yourself and refine that process, it works better than, even the experts, the ones that have experience doing it. I mean, a risk assessment is basically what a judge does, but it then follows up and checks that judge and says, if a judge could then put down as they're making a decision, which factors went into that decision and how much each one of those weighed, if that were possible, this would be then checking that judge's work later and coming back and saying, okay, you use this criteria. These were the criteria that seemed to be working. They seem to be predictive of what happened, the outcomes. And then it refines that and says, okay, let's throw out the ones that don't work and keep the ones that do, and we'll try some new ones. And then it checks that later, and it keeps refining and refining. And that's what a risk assessment is. It's just a formalized process.
And that's what that ongoing validation process is for.
Exactly right. Right.
Well,
yeah. And so it seems like that's what we all hope for, just in a more standardized, systemized way.
Well, good. I'm glad that we mostly see eye to eye, at least on the basic points. I've looked at the criticisms of risk assessments pretty carefully. And one thing I've noted is in our group, we avoided a number of the pitfalls. For example, the Virginia risk assessment tool is coming under fire because it has a question about employment that caused us to, well, at first we simply eliminated the question, but it was part of the reason that we ended up not going with that risk assessment tool. Another criticism is that people who are in pretrial services, you run the risk that if they don't comply with pretrial services, you end up locking them up, whereas maybe you wouldn't have without pretrial services. But we're not doing that. We're dealing with failures to comply in minor ways administratively. There's no question about those people being locked up. That never comes before the court unless there's a new crime. And I think a lot of people would say, a good, reliable, and consistent way of bringing new crimes to the court's attention is a good thing. I mean, maybe not to reduce incarceration, but just for the court to have, a broader picture of the defendant that's involved. So there have been a couple of those things. And of course, the big criticism is of algorithms that are proprietary. So you don't know why a person gets a certain score. And we rejected that out of hand. You'll recall, we didn't go for the public safety assessment initially because it had that feature. We only went for it when that changed. So as I look at what we've done, I think that a number of the criticisms just don't apply to our risk assessment tool. The other thing I notice is that a lot of these criticisms are focused on policy, which I think is really important in the long run. But all of us work in capacities that are more in the trenches, like Bruce was talking about, making a decision on the fly, a judicial officer, hearing 20 cases in a calendar and having to make a decision on each one. Consistent information is really important and really hard to get if you don't have some, procedure for developing it in a standard way in each case. So enough said. I just don't see that there's an alternative to risk assessments really, other than the subjective biases that got us into this in the first place. So I don't know. Anything else you all would like to talk about or any questions? Anything?
just have
we
a-
need to-
Oh, I just have a couple questions for John. Earlier, Dave was saying that we had an 81% compliance rate on the individuals on pretrial. Could you expand on that? Is that like, that's excluding new cases? That's just staying in contact with pretrial services?
Yes, that's your check-in requirements
Okay.
with all levels.
Okay. So
So if somebody, oh, go ahead, Dave, sorry.
yeah, so we've really, I guess we lose about 20% of them. I don't know if you heard my kind of suggestion. Would it be too labor intensive when you've lost contact with somebody to have that in front of the court on status? Or what happens when you do lose contact with somebody? Where does that information go?
For high level only, the court currently at the policy they have, we report that into the court for the high levels that fail to make contact. Doesn't have to be a new law violation, but it can be failing to make contact. And so we try several attempts. Within 30 days, if we hear nothing, then we get the court. But low mediums are dealt with in our office. We make all the attempts, and then that's about it. And hopefully they're still getting court reminders and their contact information is still relevant and current.
So anyone on low to medium, the court would have no way of knowing if they've had contact with you or not. Okay.
Correct.
And that is something maybe for the group I'd like to maybe propose changing at some point, because I think it is important for the court to know, not to bring action, but for future court hearings that someone has lost contact, or the opposite if someone is in contact with them. But that's something we can address. Thank you, John. I was just curious about that.
You know, I'll follow up on that. And I think Dave's right that this was before you got into the meeting, I think, John, but there are so many cases before the court that are just getting continued on, and often defendants aren't showing up and the court isn't issuing bench warrants unless it's really egregious, because we don't want to be locking people up. At some point, all of that has to get organized and people have to be, you know, back in the system and accountable to the court. And that might be, there might be a role for the pretrial services unit in that process. I don't want to turn the pretrial services unit into the police. Yeah, it's really important not to do that, but just I'd like you to think about what the pretrial service unit capacities are and whether there might be that ability to help get back in touch with defendants that we've lost contact with and keep them, you know, tied into the system while they're pretrial. Something to think about. I'm not suggesting that we do that because I suspect there are some downsides that I'm not seeing, but I'd like John and Dave Reynolds to think about those things, and we'll talk about them some more on January 5th. I hope you all can come to our January 5th meeting.
And I'm just more too about kind of the communication with the court. So the court knows that these 1/5 of people are gone, you know, are not in contact with pretrial services.
Can I call you back in 10 minutes?
I'm wondering about it if John was to file a monthly report with the court about number of contacts with pretrial.
Yeah,
So
I mean, stuff like that would be perfect. I don't want to make it too labor intensive with them, but yeah.
No, it should be a standard form, the number of contacts this month. Or, you know, every 2 months or however you decide to do it, but we're not asking for court action, we're simply bringing it to the court's attention.
Yeah, so that'd be good information to have.
Would be. I think we can move ahead on that, just that information gathering. It may not inform this group's recommendations, but it'll certainly help the court keep track of this. So Dave and John, can you work on developing a form that gets us the information we need?
Yeah, I think we just modify one of our current forms that we use.
Okay, good.
Did you see an issue, John?
No, not at all. I think that's a good idea.
Okay.
Okay.
I think if it contains last contact and then number of contacts, current contacts or something like that, that would help give the court some guidance.
No, we're not talking on each individual having a report submitted, but an overall general on the whole caseload.
No, I think we're talking in each case.
Oh, okay.
why don't you develop the form and start using it? Let's see how that impacts workload, and if there's a capacity question, then we'll address it or modify the request or whatever. But let's get started with that so that we can start to get that information.
I guess one question I have, just because of workload, should it be reporting those people who are not in compliance, or do we need to report those ones too who are checking in?
I mean, my preference would be the people not in compliance right now, because I think with all of them it'd be way too labor intensive.
I agree.
Yeah.
So I think
I'd like to at least start with that, so at least the court can know
yeah, I think
what
that's-
people have
that's
been in
more manageable.
compliance. Yeah.
That
You
makes
can
sense.
still contain, when the last contact was, and then, information about current, but just those people who aren't currently in contact with pretrial services, it should be.
Okay.
Because I know a few times, a couple of the judges have been asking us, and we have no clue.
Yeah.
They've just said, and so they've kind of defaulted. Well, if there's nothing filed, then sounds like they're in compliance. Sort
But
of
it
deal.
still
Good
remains
news is good
administrative
news.
on our part because we're simply reporting information to the court.
Yeah, that sounds good.
So this would just be for low and mediums because the highs already have something in place. If they don't comply, they're already notified the court. So,
Correct. John?
okay.
Yeah, correct. Yeah. John, do you have any suggestions or things that you've noticed? I know you worked at this before that we're not doing or that we are doing that can sort of help pretrial?
Well, if we get a standardized form, it's usually the software that needs to cooperate with us. The PSA is very labor intensive. It's manually done on each question and each case because the state doesn't share the information with our database. It's a private vendor we use. That part is kind of tough, but that's something that can't be resolved. But if we can get some of these forms within our database that you're requesting, that could really help out, minimizing our time, and the database will keep track of everything for us. And we can go to the private vendor and maybe they can modify it and give us that form or something like that.
All right. Why don't you find out what you can about that? And we can talk about it further at our January 5th meeting.
Good.
Well, as Judge Olson would say, for the good of the order, does anybody have anything else for us to discuss at this meeting now? Well, we're going to meet again on the 21st at noon. And those of you, you've stamped your tickets, those of you who are here, but if you'd like to be at the meeting on the 21st, that would be great. And further discussion at that meeting with the rest of the group. And then we should be ready to make some decisions at the January 5th meeting.
Judge Garrett, Jill here. If you've got a minute or two, I've got some housekeeping items to discuss with you after the meeting adjourns today.
Okay, so should I just stay here in the meeting?
Sure.
Okay, that's what I'll do. Thank you all. I'll say this in a more articulate way when it's the last meeting, but I sure have enjoyed working with all of you on this group. And I really think, despite the current vacuum that we're in, that our work has made a difference and is going to continue to make a difference on incarceration rates in Whatcom County. I think we've done good. So thank you all. I hope to see you on the 21st, but all of you, hope you have great holidays. And as they say, see you next year, January 5th. Okay?
Thank you, Judge Garrett.
Thanks,
All right.